Brian Parker here, attorney Brian Parker. Got a new one for you, and a simple one. This is a simple tactic with a tremendous upside to kill the debt collector lawsuit. I'm going to title this Motion to Dismiss for Lack of Proper Title. Everything in a collection lawsuit or any lawsuit is based upon standing. What is the right of the person? Do they have standing to pursue and sue you? So, like, love, and subscribe. Keep an eye on Natalie's documents vault. She's building that every day. It's all the we have over 1,000 forms on our website, KillDebt.com, KillDebt.com, and that is building daily. Have patience with her. If your debt collector or creditor isn't showing up, it will. But today is a great little tactic, a simple tactic that I touched upon in my last video against LVNV funding that was collecting for a Cross River bank. First, we want to look at the method or the definition of standing. Standing is nothing more than proving, let's say if someone's suing you for breach of contract, they have to have the contract in hand that you signed, the terms and conditions, so therefore they can allege that you guys had a meeting of minds, an agreement, and you breached it, and now damages are owed. But you got to have proof. You got to have standing. And in these cases, these debt collection cases, they are contractual per se, but standing means I've got the right to sue you, and especially in debt buyer lawsuits where they're buying debts for pennies on the dollar. And again, I implore you, just look at the bill of sale or bill of sale and assignment or transfer documents. They all say, without recourse, or we don't represent, we have any title, you can't blame us if something goes wrong. Well, there's a reason, because they're selling horribly proven debts for pennies on the dollar. And so you will use that against the plaintiff. So if you can show neither a bill of sale or assignment or a contract, or as in most account stated cases, which we talked about in my last video, and most videos. In fact, look at my videos on account stated statute, counter affidavit. There's a couple up there, swish, 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 boom. They are all based on the theory, it's more than the theory, it's practical application in most states, that when there is no contract or proper documentation, a debt collector will attach an affidavit of account. And that's why I preach so hard that you must produce a counter affidavit. And that counter affidavit, as I showed you, maybe I did, maybe I didn't, but I will in this video, when you are attacking their proof and that proof is affidavit, knock out the affidavit, you knock out their case, you knock out standing. So the other issue they have as far as you attacking them for lack of assignment or proof of purchase is the securitization problem. Every one of these debt by debts, especially Cross River, any fintech loan, they have major issues now because the very essence and genesis of the fintech loan is that it's going to be securitized. So the funds are released, it's originated, they immediately securitize to all these tranches. The person defaults, now they got to somehow get it to a debt buyer to go chase you, and there are so many people that own it, so they put together schlocky proof, which they don't really care. As I said, 9 out of 10 cases are going to get defaulted anyway, so there's no care. You just be in that 10%. So securitization is going to hurt them. Where am I going with this? I'll have 3 motions, word template motions that I filed. One I filed, today is Thursday, I filed it Tuesday, and Wednesday they call, you know what do you want? We're out. That's after filing a motion to dismiss. And what you're doing is you're all just calling them on their bullshit. I can't think of a better legal way of saying that. But it's a unique, cool tactic now. You file a motion to dismiss and attach that in the alternative a motion for a better statement, a better proofs. I think it's called in some states more definite statement. The idea of both, so a lot of times judges feel like they have to cut the baby in half. So they go, well, Parker, I'm not going to give you the motion to dismiss, but I'll make them give you better documents. Well, if they don't have better documents, then I win the motion to dismiss. Why are you bringing a piece of crap case? But anyway, I digress, as always. So what you want to do, you need to create your counter affidavit by using their documents against them. You've heard me say that many times. And for the court, you do the following things. Let's put it up here. Shazam. You first create your synopsis of the chain of title. And that is simply put, let's put it up there now what that looks like. Starting with a broken chain of title, Shazam. And you literally, for the court, will tell the court exactly the loan occurred such and such a date with the original creditor, somebody bought it, here's all the chain of title, and you can display for the court all the weirdness, like a bill of sale that does not have my name and account number and appears to be selling something they never received. You can break it down, keep it one page, because everybody's attention is so skewed, especially with hundreds of cases. But have a one-page synopsis drawn from your counter affidavit. So those two go together as far as creating the counter affidavit. You then file with that attachment and the documents you're pointing out to the court show complete lack of standing. You file a motion to dismiss, or in the alternative, motion for more definite statement. You're asking for the same thing. The first motion, you're saying, just get rid of this. The second part of that is, well, if you're not going to go with me, even though you can clearly see there's a problem, make them answer the lawsuit with, create a new lawsuit or produce better documents, but they don't have it. They would have brought it already. And usually when they go to great pains to kind of fix the problems they have, it just makes it better for you. So it's a chance for an early knockout. So let's put those categories up again. Shazam, first create your synopsis, create your counter affidavit, a motion to dismiss, show the court the plaintiff lacks the legal capacity to file and maintain the lawsuit against you, and why, and that's your counter affidavit. Your counter affidavit follows you through the sea of litigation. Wherever you go, it's going to be a gold standard for you. And it is a chance for an early knockout. If it isn't, you just educated the court to what a schlocky complaint they have against you and how on the ball you are. And it puts the plaintiff on the defensive. You're not calling them, they're calling you. And like I said, I filed that motion to dismiss, or in the alternative, prove you own the debt. It was a Cross River Bank the LVNV had picked up. They text, this is rare. They emailed me to say, please call us. Because I don't talk to anybody unless I have to. So because you got to put everything in writing. So we talked, it goes, and I'd asked for a kind of a large amount of money. And they go, well, is there any flexibility there? They're talking about how much they don't have to pay me when they sued my client. And that's a motion to dismiss. You're just calling them on their stuff and presenting it to court. They don't want the court seeing this, all right? Because they're on the broken theory that, and it's correct, 90% of these cases are going to get dismissed anyway. Why do we care? They just put anything together. So you'll see those three motions. I think 2 against Velocity, 1's against LVNV funding. And they will be in Word template for you to use. Just add your state law and facts. The strategy behind challenging standing. You're attacking the original contracts. You're attacking the proof of the debts swimming through the chain of title. A good example, if you look at my videos on SLM, let's put, I think I got 2. 1, 2, student loans and SLM. They have such garbage chain of titles. I tell you what, one of the motions to dismiss, or in the alternative, prove you have the documents, is going to be an SLM one. And you can just see it's just awful. And then in this example, you'll see in the motion, there's one page where everybody sat down next to each other and signed and on the side, and it's clearly not the same document as the bill of sale, because nobody sits down and signs. Like 10 people sign a bill of sale that's kind of general anyway. You'll see the motion. So you're attacking their documentation. If there's an affidavit, sometimes all they have, look at, if you get sued by a debt collector or debt buyer, sometimes all they have is the account stated affidavit. You knock out one of those. The video with LVNV funding, let's put it up there for you, Shazam. I just did that 2 days ago. That was attacking the affidavit, and I did a linchpin on linchpin. I showed the lawsuit, and then I showed the actual specific linchpin of the lawsuit, and there were two. I think it was paragraph 6 and paragraph 11. 11 says, we're relying on the account stated statute. So then I looked at the linchpin that was holding the whole thing together, and they actually opened themselves up for a greater analysis of how bad they were. So again, that was done in 24 hours, and that was a lot of money they're going to eat. So have something, this is an expression, have something the court can hang its hat on. It can say, I see what Parker's talking about. I can hang my hat on that and feel comfortable dismissing this case. So state a failure to state a claim. There's no facts, there's no law on their side. And you can, again, I'll give you the 3 best ways to knock out a case. Lack of standing, of course. If they don't have a proper chain of title, it's actually in the business called a perfected chain of title, which is kind of an interesting title. Or if they lack personal jurisdiction or improper service. Remember I just did that video about an unwanted visitor with the funny raccoon at the end? It wasn't funny if you're living it, but that's about improper service. And you can file a motion to dismiss if you weren't served. I regularly hear from people that say, they just threw it at my door, or they stuffed it in the mailbox, which is not personal service. So that's a reason to file a dismissal motion and bring attention to the court. I think the number one thing with a lot of these cases is you're educating the court about your side, educating the court that if it keeps this case going, it's going to have to show real good reason for it sticking around that can be appealed. That's the only thing judges really care about is re-election, which is usually a sure thing unless they did something weird, or an appeal. And I've talked to judges, they don't like appeals. So if you keep presenting a reason why, this is getting kind of sticky, and then you start seeing the judge kind of give it the business to the other side more than usual, now you're on the right path. It shouldn't get that far with one of these motions. A good thing about filing one of these motions, if you're unsteady, you know they've got some bad stuff, but you need to shore up your side, it's a good way to extend the time. So here's how it works. You are required to bring an answer within, let's say, 21 days. But if you file a motion to dismiss, the answer requirement of 21 days falls back until the motion to set us to dismiss or for more definite statement is heard. Make sure you set it for hearing. And until that's heard and decided upon, you don't have to file an answer. And usually once the court has ruled, if it didn't go your way, but it's always going to go your way, they're either going to have to produce documents or it's going to get dismissed. And in fact, a lot of state rules say that if you win a motion for more definite statement, they only have a finite amount of time to get their documents, which if they didn't already have it, it's going to take forever to go back to the original creditor and do all this nonsense. So the big point of this is you're going to get that case settled like I did within less than 24 hours. Statute of limitations is another way to go in for a motion to dismiss. Once you file those, there's a really good chance you're settling that case. It's probably a nice way, a good tactic, because it really puts the other side on their heels. I see it all the time. I'm doing it more and more. I'm going to attach this video at KillDebt.com an SLM, a velocity, and an LVNV funding motion to dismiss or more definite statement of documents. So you're focusing on the debt buyer, who, by the way, should be focused on. They have the burden of proof, and you're saying they have not met their burden of proof. So what is a risk or a downside of filing this motion? I believe there are none, because you've gained more time. If you lose that motion, the court's going to give you something. It's going to say you need more documents, and you're educating the court. And the debt collector now is on the defensive. They're playing catch up. That's a good point I want to make. You put them on their heels, and now they're playing catch up, and the court's not looking at them favorably. I've got to tell you, I've done a lot of years in a lot of cases. A lot of judges hate debt collection cases because they're so bad for their people that are voting for them. And if the person doesn't show up, that's an instant default. And the court, most judges are no dummies. They can see they don't have the proper proof, but if no one's fighting it, 9 times out of 10, the judge has got to give them the default. So you're doing the judge a favor. You're letting him hang his hat on deciding for you if you give him enough reason for that. And it's a chance for an early knockout. And there's plenty of judges that don't like these kind of cases and would love to knock them out. And so you're helping the court. It's always good to help a judge. So check your local rules. What are the time limits? In each state, you're allowed to bring generally allowed to bring a motion to dismiss instead of the answer we talked about. And what's the time limit when you have to do that? How many days from the hearing must you file it? And then you got to set the hearing. They have a chance to answer. A lot of times their answer will actually help you. Like, people they can take one approach to anything negative. But if I get a motion to dismiss filed against my case, let's say I filed in federal court, which happens, they'll file a 12B6, which is, hey, this complaint sucks. They'll point out why I've done a bad job, right? So I love that, because it's instant research for me. So if they file a response and saying, sure, we did this right, 9 times out of 10, it's going to help you, but in a different way. They'll hang themselves. They'll just get themselves more rope, because they'll twist and turn with the pretzel litigation of something they can't prove anyway. So in the interim, they've actually created worse problems for you to go in and go, aha, and you're allowed to reply to their response. So you can just say, oh boy, they doubled down in the muck. They've made it even worse, and then point that out. Court may let you have that one. So let them respond. It's only going to help you. It's a positive thing. Keep in mind, if you're filing a motion to dismiss or an answer, bring it or lose it. So if you have jurisdiction issues, improper service, some of those things, the rules require you bring them immediately with your responsive pleading, which is your answer, or your motion, or you lose the opportunity to complain about that. So keep an eye on the rules in that regard. Again, motion alternatively. I want this, or in the alternative, I want this. You're allowed to do that under any court rules. You can say, I want this, but if you don't think I got it, how about this over here? And all you're doing is appealing to the court's sense of neutrality. So if you just went in on a motion to dismiss, you're probably going to lose that early. But if you've got the alternative, the court, just by the humanness of it, will, oh, I can give him something and give them something too. But that something in the alternative really smacks them up, because now they got to produce something they never had in the first place. You're probably going to get that case settled. So on KillDebt.com, you're going to have, I may have 4 motion to dismisses in the alternative, in the alternative, make them bring better documents. That type of motion, each has its own name. But I'll have 4. I'll have counter affidavits for each of those cases. So you can just apply your facts and rules. And if it's a velocity or LV&V fund, it's probably all going to be the same stuff. You just put your name in, put your facts. You'll have my show notes. And just for the heck of it, I'm going to give you a list of cases that I will look at and use if they fit. Assignment cases, document cases, chain of title cases. I'll attach them to my show notes, and you can use them, research them, make sure they're still good. I'm still using a lot of them. They're Michigan, but there's also multi-state, lots of other state assignment cases. So think about this. It's a quick and simple, down and dirty way to strike fast and probably settle the case. It's filing your motion to dismiss, or in the alternative, let's just call it, give me better statements. It's a motion for more definite statement. Statement is interesting because they should have account statements. And even if they do, that doesn't prove ownership. I counsel in a lot of these motions, you'll always hear, but Your Honor, he paid on the debt. But Your Honor, he doesn't deny owing the debt. But he doesn't owe it to the debt collector. So always have that snappy retort. You separate yourself from the debt and the debt collector. Separate yourself from the debt and the debt collector by showing they don't own it. You may owe it, Your Honor, but I don't owe it to this guy. So I hope this helps. Go do your quick, down and dirty motion to dismiss. Thank you.